Good afternoon, and thank you for participating in today's webinar on 5 things every medical practice must know about California employment law, presented by the Rose Group. I'd like to touch on a few things and inform you that you are in mute status only, so we will not be able to hear you speak we won't hear any background noise. So if you have any questions regarding the webinar, please type your questions in the side panel under the questions tab, and we will make sure that we answer your questions at the end of the presentation. I'd like to read a bio on our presenters today. Ken Rose and Robert Rose are the principals of the Rose Group, APLC, an employment law and HR consulting firm. Ken has practiced employment and labor law for nearly 40 years. The Rose Group is a corporate partner of the Physician Resource Center. It advises medical groups and physicians with respect to employment contracts, employment and HR law issues, employment policies, procedures for medical offices, wage law matters, and implementing preventive measures to reduce potential liability for employment practices. Additionally, the Rose Group provides hands-on counsel to medical groups facing difficult employment decisions such as terminations and defends medical groups in litigation filed in court and before administrative agencies. Before we get started with the webinar, I'd like to share 3 poll questions with you. If you would take a few seconds to answer each poll question, I will display the first question here, and there you go. Another 5 seconds. Okay, we'll move into the second question. Another 5 seconds. And we'll move into the third question. Give you another 5 questions there to answer. And we'll close that. And I will hand off to Kenneth and Rose. I'm sorry, and Robert. I apologize.
Thank you. Thank you, Veronica. We're going to be covering 5 topics that we picked, which we think are essential to have general knowledge of, because these are matters of employment law that are going to be coming up time and time again. The 5 areas that we're going to cover are, first, the difference between an exempt and a non-exempt employee, and that's a wage and hour law issue. And then another wage and hour law issue will be our second topic, which is meal and rest breaks and overtime. Then we're going to cover 2 issues involving really medical leave or leave related to illness, injury, and so on. First, the new California sick leave law, which takes effect July 1, and then other laws including the family and medical leave laws. Then last, number 5, is going to be just hitting on employment policies and prevention practices to limit employment liability, both the development of policies, the communication of those policies, and the implementation of those policies. Okay. We'll start with the exemptions. It is very important because there are certain rights that non-exempt employees have that if they're not provided those rights because you mistakenly believe that they're exempt employees, that can be very costly. Employees under California law are considered exempt by default, but they can not exempt by default, but they can be classified as exempt if they are executives, administrators, learned professionals, or outside salespersons. In addition to fitting into one of those job categories, they also have to be paid a minimal salary or they will not be exempt despite their job duties. The minimal salary is equal to an hourly wage of 2 times the minimum wage, and you base it on a 40-hour work week. Currently, the minimum wage in California is $9 an hour, and that translates to the minimum weekly salary for an exempt employee, $720. On January 1 of next year, the California minimum wage goes up to $10 an hour, and based on that, then the minimum salary to keep someone exempt is going to be $800 per week. We have found in our experience that many medical practices do make mistakes, particularly believing that simply because they pay an employee on a salary basis, that employee is exempt. But the salary component is only one part of what makes someone fit the definition of exempt employee. Perhaps the more important component is that the employees also have to spend at least 50% of their work time exercising discretion and independent judgment as a manager, administrator, or a professional. In the typical law office, we have found clerical workers, medical technicians, LPNs, you generally are going to be your traditional non-exempt employees. Office managers often become a real problem because not all office managers are spending their entire time managing. And because California has this rule of 50% of the time must be spent on exempt duties, if your manager is spending 20-30% of the time managing the staff and the other 70% of the time kind of doing the same work as the staff's, helping at the reception desk, helping here and there, that's not going to be an exempt position. With regard to nurses, particularly RNs, that's a real fuzzy area of the extent to which nurses, particularly nurses in medical offices who may have duties other than doing straight nursing work, are indeed exempt employees. This slide just to tell you that there are severe consequences, financial consequences, if employees are misclassified. And the next slide we're going to get to deals with the one area where the employees who are non-exempt have certain rights where you don't have to worry about with regard to exempt employees. California has some pretty strict rules regarding providing rest periods and meal periods to non-exempt employees. The meal period requirement is at least a 30-minute off-the-clock meal period, no later than when the employee finishes the 5th hour of work. And if the employee is on a longer shift that extends to at least 10 hours, then they're entitled to a second 30-minute off-the-clock meal period. The rest periods are on the clock, and they are 10-minute rest period for 4 hours work. The stickler here is that any employee that is denied their right to a meal or rest period is entitled to 1 hour wages for each of those breaks that are missed. And while then in the abstract that may not sound like a lot of money, if you have a systemic practice of not providing the proper rest periods and meal periods, and that can be as much as a 4-year statute of limitations, the numbers exponentially can add up to hundreds of thousands, and in fact, in larger companies, many millions of dollars. Okay, next is the overtime, and this is the other area where non-exempt employees have a significant different rights than exempt employees. Under California law, overtime is due based on a daily basis as well as a weekly basis. If an employee works more than 8 hours in a day, they're entitled to overtime at time and a half for the additional hours. If they work more than 12 hours in a day, then the 12th and any additional hours beyond that are double time. Also, if an employee works more than 40 hours in a week, then every hour beyond 40 is at time and a half. Many offices do consider what are called alternative work weeks. The most common alternative work week is a 4-day work week of 10 hours per day, and the office is closed or the employees are not required to work, say, on Friday. There are certain provisions in the California law that allow for such alternative work weeks, and if you go through the right process and are certified to have an alternative work week for your employees, then on those days where they're scheduled to work more than 8 hours, such as if they're working 10 hours per day, they would be 2 hours over 8 each of the days. Those 8 hours are not going to be considered overtime to be paid at time and a half. If there's any hours worked beyond 10 in the day, they would be at 10 and a half. If there's any hours worked in excess of 40, it's time and a half. But in order to have the alternative work week exception, there is a requirement that you have a secret ballot among the employees to approve it, and there are other requirements. It can't be just simply implemented. An important factor in overtime is that by and large, if an employee works an overtime hour and they're actually doing work, doing productive work, even though they haven't been authorized to do the overtime, generally the employer is still going to be legally obligated to pay for the overtime. The way to deal with the rogue employee who's working overtime without the proper authorization is through the disciplinary and termination procedures. The last note I have on the slide is that there's some different rules for medical offices that operate clinics performing hospital-like procedures such as inpatient surgery. I'm not going to go into those now, but there are some different rules that are really apply to hospital staff, but some medical offices are going to fit under them because some of the work that you do may be similar to what goes on in a hospital. Okay, now we're going to move on to the leave laws. First one is this sick leave law. This is a new mandatory law passed by California. It goes into effect July 1, 2015. This has never existed before. The basic requirement is that every employee, exempt or non-exempt, is going to be entitled to earn paid sick leave. And there are going to be two options for the employer in terms of how sick leave is earned by employees. Option A, or option 1, is that for every 30 hours that an employee works, they get credited 1 hour of paid sick leave. Based on a full year at 40 hours a week, that's going to be about nearly 8 days, or maybe a little bit more than 8 days per year of sick leave that are accrued. The option 2 is, rather than having an accrual, the law provides that the employer can provide on the first day of the year, or in this case, July 1st, since the law is only going to be in effect half a year, a fixed number of days of paid sick leave. The number is 3 for a full year. The 3 days would be provided, say, on January 1st of 2016. The employee automatically has those 3 days. They don't have to work any hours to get the 3 days. However, they will not accrue any more. For this year, I believe that you probably could just credit the employees with 1.5 days of sick leave on July 1st, and to get around the accrual question. Now, if an employee does use paid sick leave, even though they have accrued more than 3 days, the employer can limit the number of sick days used in any single year to 3 days, with the remainder, if you're on the accrual basis, carrying over to the following year. The reasons for using paid sick leave extend beyond the employee's own illness or need for medical attention, and would include the employee's need to be with family members because of their illness or injuries, or even to attend necessary doctor's appointments. And again, this law goes into effect on July 1st, and each of you needs to at least understand the rudiments of it and add it to your policies and procedures. Okay. The next slide, it deals with some other leave laws. We'll go through this a little more quickly. The first 5 items, Family Medical Leave, California Family Rights Act, Workers' Comp, Americans with Disability, and Pregnancy Disability, that all are forms of medical leave. The first 2, Family Leave and California Family Rights Act, they're basically the same law. Unless you have 50 or more employees, you don't need to concern yourself with these laws. What the Family Leave law provides is that the employers are entitled to 3 weeks of medical leave or maternity-type leave per year. It's not paid for. The only financial consequence for the employer is they have to continue the group health insurance coverage for the employee. And at the end of the leave, if the employee returns at the end of the leave, ready to go back to work, you have to be reinstated. Workers' comp, I think you're all familiar with. I think the key here in terms of the leave is that once someone is on workers' comp leave, it's very difficult to terminate them or even permanently replace them in some way. You need a very strong business justification, and this is an area where you really shouldn't act without speaking to counsel first. The Americans with Disabilities Act is a very broad law, and it basically protects individuals who have different kinds of physical or mental disabilities, but who are able to perform their jobs sometimes with accommodation. And it provides for that the employer does have an obligation to reasonably accommodate. With specific regard to leave, one of the reasonable accommodations that the courts have credited is a leave of absence or taking time off to attend doctor's appointments, that can be a reasonable accommodation under the ADA. The pregnancy, and by the way, the ADA, the California version of it, applies to any employer with 5 or more employees. So most of you are going to be covered. Pregnancy disability leave law similarly applies to any employer with 5 or more employees. The essence of this law is that a female employee who is disabled due to a pregnancy or as a result of childbirth can take up to 4 months of medical leave due to those reasons, and that individual would be entitled to reinstatement at their regular position when they return in most instances. The last areas of leave I mentioned, military leave, there's federal and state law on that. By and large, an individual is being called into military duty. The employer is going to have to allow them to take the time off. Jury duty is something it's required by law. Someone attends jury duty, the employer can't tell them they can't go. But there's no obligation to pay the wages when someone is attending jury duty. Time off to vote, basically the law is that on election day, if the employee shift precludes them from voting before or after work, the requirement is that they be given at least 2 hours off to vote. Okay. And the last issue is policies, procedures, and prevention. Employee handbooks are something that most businesses and probably most medical offices have in some form or another, but how complete they are, how accurate they are, whether they have everything in there that should be in there, whether they have things in there that are better off unsaid, is really the key. Certainly, we would recommend that the matters that we've discussed today, breaks, overtime, what your leave policies are, those should be included in the handbook. You would have your standard anti-discrimination statements, anti-harassment statements. Certainly, if the business is run on a way that everybody is employed on an at-will basis, then there should be a statement in the handbook stating that all employment is at will and can be terminated by either the office or the employee at any time for any reason, with or without cause. The key with any employment policy is that it's practical, it's relevant to your business, it doesn't provide the employees with any rights that you don't want to give them unless it is required by law, and that it is communicated to the employees in a way that they are on notice and you can perhaps even prove that they're on notice. The fourth bullet point, signed acknowledgement from employees. It is always good when you distribute an employee handbook or other policies and procedures to get a signature from the employee acknowledging that they received a copy and put that acknowledgement in their personnel file. The employee handbooks or your policies, it would be prudent to have an employee complaint or employee grievance procedure. And the reason for that is a lot of things that land up in litigation, had the employer known that there was a grievance early on before counsel was brought in, they might have been able, you might be able to nip it in the bud. And so you at least want to have an avenue where the employers believe they can make a complaint. It would be honestly and fairly looked at, and it may give you an opportunity to ward off things getting out of control. The next to last bullet point, time cards and conforming wage statements. This really goes back to the non-exempt employees. A requirement of law is that all non-exempt employees have to keep track of their time, or the company has to keep track of their time. They have to have time cards which indicate when they started work each day, when they went to began their unpaid lunch period, when they returned from their unpaid lunch period, and when they stopped at the end of the day. The wage statements, the payroll stubs, and so on. There are certain requirements under California law as to the information that must be in the stubs. The last bullet point, and I guess the last thing I'll say before the questions is employers should know when an issue is serious enough to seek expert guidance. If you are responsible for HR in some capacity at your office, you're not expected to have the knowledge of an employment lawyer. What your goal should be is to have enough rudimentary knowledge of employment law and good instincts to kind of pick up when things don't feel right and get in front of these issues before any decision is made, before you terminate someone, before you give them some kind of serious misconduct, maybe even before you address an internal harassment complaint. You know that there is something that needs to be dealt with, so you're concerned about it. That's the time to get expert help. Usually calling an employment lawyer at that point is the best use of the lawyer's time. And you get out in front and you come up with a strategy to address the issue rather than be reactive, where we find so many of our clients that will terminate someone. It's not done as cleanly or as carefully as it should be done, and then ask us as lawyers to kind of undo it, and it's very difficult. You know, once Humpty Dumpty is broken, it's hard to put it back together again. So that is a quick and dirty summary of some very important employment issues. There's plenty more detail on each of these factors that we raised today. We don't have time for that, but we will take your questions now.
Thank you, Ken. There are some questions that have come through. What I'd like to do here real quick is go through the poll questions and answers and see if there's anything to touch on those. And the first question, are you responsible for performing the HR functions at your medical practice? It looks like we had 86% answer yes, 14% answered no. Is there anything you'd like to touch on this?
No, I mean, that's good to hear, because that's the audience that needs to be participating in programs like this. So congratulations to you for taking the time.
Great. And the second question, does your medical office have an employee handbook or other written employment policies and procedures? It looks like we had 100% answer yes. And
okay.
Oh, go ahead.
My comment to that is that is your handbook structured and melded to the actual needs of your office? Number one. Number two, is it something that you simply picked up from someone else and just cut and pasted? Or is it originally, it was some time taken to decide what should go in it and what should not? And third, how long has it been since it's last been updated? It's important that the handbook will be reviewed from time to time to make sure, number one, it covers current laws such as the paid sick leave law. Number two, that it doesn't provide policies that you really don't want to implement. For example, I've seen many times that companies have almost gratuitously had policies that said, before we will hire someone from the outside to fill a position, we will use internal candidates. But then when the position is available, they really don't want to do that. They want to they've got some candidate who's outside of the office that they want to bring in. Well, by doing that, they violate their policy. Now, you didn't need to have that policy in the first place because there's no law that requires that the job that you always have to hire from within. So don't put it in your handbook if you're not going to do it. So those are kind of things to look at. All I would say is that it should be reviewed from time to time because it's an important part of your HR approach, and it's an important communication to the employees.
Great. Thank you for sharing and elaborating on that subject. Our last poll question here is, are you aware that there is a California paid sick leave law that takes effect on July 1st? It looks like we had 24% answered no. So,
okay. Well, hopefully that 24% is now educated, and do all of you, if you do not have a written policy in place now, where you have to make some decisions on whether you want accrual or whether you want lump sum, get on board because it's almost June.
okay, so we'll let's see. We'll address the questions that have come through, and the first question is, will these slides be available to us after the presentation? And the answer is yes. Everyone who participated in today's webinar will be emailed a copy of the slides, so you will get a copy. Second question is, am I understanding that full-time employees get an increase to 8 days per year?
Well, I think that the question probably is talking about this paid sick leave law, and if they work a full 2,040 hours, just 40 hours a week, 52 weeks a year, then yes, they will. Those employees will accrue approximately 8 days of paid sick leave.
Okay, another question is, how often, I'm thinking that maybe they're asking, how often can an employee take FMLA?
Okay, the employees can, most businesses choose a way that they measure the year, whether it be the calendar year or they measure it based on when the employee first takes FMLA leave. But whatever the measured period is, the employee can take up to 12 weeks. So if you base it on when the employee starts, if an employee tomorrow asks for family medical leave and they are they're eligible for it, then between tomorrow and late May of 2016, they'd be entitled to take up to 12 weeks and still have right to reinstatement to their job. And then the following year, again, that they would have 12 additional weeks.
Okay, next question. Does the Family Leave Act apply to offices with less than 50 employees?
Okay, it does not. And now there are businesses that understand that even though they're under 50 employees, they don't have to provide benefits similar to what the Family Leave Act provides, but nonetheless they do so on a sort of a voluntary basis as a benefit to the employees. But unless you have 50 or more employees, no, there is no obligation to follow the tenets of that law.
Okay. Any recommendations about how much time to recommend for pregnancy leave if employee asks, what is the office policy for pregnancy leave?
Okay. This is going to depend on whether or not the business has 50 or more employees. because if there are 50 or more employees, then under the family leave law, the female employee and also the husband as well have a right to take maternity leave, or I guess you can call it paternity leave, which is for caring for bonding with the newborn. If the practice has less than 50 employees, you really don't have to provide any leave for that purpose. The pregnancy disability leave is a different law. That's one that applies to offices with 5 or more employees. And any offices of 5 or more employees would have to provide leave to the female employee who, due to a pregnancy or childbirth, is rendered by their personal doctor to be disabled from working, or it could be that they're disabled from working the regular job and should be given a light duty job. And that would be up to 4 months of leave, but it's not a guaranteed 4 months. If the disability due to pregnancy only lasts for 6 weeks, then the employee is only entitled to take 6 weeks under the pregnancy disability leave law.
Okay. Here's another question. My full-time employee is out on disability. She is critical to office operations and her position is unique. The injury recovery is dragging on for many weeks. I need a full-time person. Office productivity is suffering. Can I let her go to find a full-time person?
Okay. The issue is going to be more complicated if the reason for the medical leave is a work-related disability. In other words, something where she's eligible for workers' comp. And the problem that you have is that when an employee is on a workers' comp leave, there is a extreme burden on the employer to demonstrate business necessity to replace the position. I mean, you pretty much have to almost show that the office would not be able to function and without filling that position, and that it's just not conceivable to fill it with temporary employees or with your other employees filling in. It's a pretty high burden. If it's a non-work related disability and the employee is not on kind of an FMLA leave, they may be entitled to leave under the ADA, and that needs to be considered. I'd say in all these instances, you want to proceed carefully. You want to kind of pressure in a nice way the employee and the employee's doctor to give you a good prognosis of when the employee is going to be able to come back, if ever, whether there's going to be any continuing need to accommodate. In other words, can they be able to come back to their regular job duties? It's a very fact-intensive question, and certainly those decisions cannot be made lightly, and there are no black and white rules. It's a pretty gray area.
Okay, another question. Do you know of a company to help with the policies that are required by law for the employee handbook?
Yeah, the Rose Group. Yeah, we do that. We work with our clients to review and to write policies as necessary, and get you on the right track. And we do have some special deals that we provide to members of this organization. So you can contact us about that.
Okay, here's another question. So an employee that is on salary and not in a management position would be considered non-exempt?
An employee who is on salary and
not in a management position would be considered non-exempt.
Well, not necessarily, because the exemptions are not just managers. A doctor, a medical doctor certified to practice medicine in California, even if he or she doesn't supervise anyone, is exempt from the overtime laws, and so therefore, they'd have to be paid the salary, but they would be exempt. There are certain things called administrative exemptions, which are people who have some fairly sophisticated training and have a lot of independent judgment and discretion on important matters for the business, who also may not manage anyone but could be considered exempt. So the exemptions are a little bit broader than just managers. But in each instance, it's the duties that are performed plus that the individual is paid that minimal of twice the minimum wage.
Okay, here's a question. We group vacation and sick leave under PTO. Would it be acceptable to accrue 1 hour sick leave per 30 hours and label as PTO?
It would. The reason that you may or may not want to do that is that any vacation time or PTO that's accrued, when the employee leaves, they're entitled to be paid for whatever is unused. Any hours or days that are unused have to be paid out at termination. Under the paid sick leave law, whatever has been accrued but has not been used at the time the employer terminates employment does not have to be paid out. So that would be the biggest factor, I think, in your case, whoever raised this question, as to whether or not to integrate the PTO as being both vacation and sick time. The other thing is that for companies that only provide PTO to, let's say, full-time employees, you're still going to be obligated to provide the paid sick leave to those who are not are not eligible for vacation or PTO. So you may need a separate sick leave policy anyway to cover those who are not entitled to any PTO.
Question here is, are there any CME credits available for this webinar?
I'll leave that to you.
No, this webinar was, unfortunately, there are no CME credits available for participating in this webinar. When counting 50 employees, is it 50 full-time, or does part-time count in the 50?
Part-time counts.
Okay. Let's see. For pregnancy disability leave, we should rely on the date the OB releases the patient as the date the patient should return to work?
Well, yeah. I mean, it's basically when does the medical professional say that the employee is fit to return to the job duties. Under the pregnancy disability leave law, at least during the 4 months, the employee could be rendered partially able to work, in which case there's an obligation to try to find some light duty work. But you rarely, yes, but you're basing it on the opinion of the medical professional as to whether the employee is ready to return to work. Whether the employee wants to return to work or not is not as important as whether the doctor says that the employee should, is medically able to return to work.
Okay, this is actually in addition to the question that I just previously asked. It says that I stepped away for a moment, so you may have answered this already, but as to the new sick leave law, why would an employer ever choose option 1, the accumulated sick leave hours, over option 2, the 3-day limit? And
Well, the reason would be is that the time has to be accrued, so you don't get the 3 days right up front. As far as I'm concerned, the option 2 is more practical because you don't have to keep track of the accrual. Otherwise, you have to keep track of the accrual just like you keep track of accrual of vacation time. So the 3 days is, sort of I think an easier way to go about it. You know what you're giving up front. You don't have to keep track other than how many days are used. So yeah, as I'd say, in a lot of instances, it makes sense, but it's just optional.
Okay, so let's see. Does the sick leave carry over year to year?
If you use the accrual basis, yes. Whatever is unused carries over. Now, I don't know that I mentioned this, but there is a provision in the law that you can put in your policy that the maximum accrual, I forget exactly what it is, but it's something like 8 days or 9 days. There's a certain number of total hours that you can say you cap out at that number, and you can't accrue any more sick leave above that number, and until you use some sick leave, you won't accrue anything further until you go under the cap. So you can't have that kind of a cap.
All right. Can there be a separate PTO policy for employees per department? We have several employees who work under 20 hours a week. If they call in sick, would we pay them sick leave or only the hours that they were scheduled to work that day they were out?
Okay, that's a couple of questions. The first part was, can you have different PTO policies for different departments? Yes. You can have different PTO policy for each employee. There's no obligation to provide any PTO or vacation or paid vacation, so therefore it can be a different, you could have a different deal with everybody, and certainly you can differentiate by department. Just make sure that that's put in writing and it's clear who's entitled to what. Now, if you can repeat the second part of the question, I'll try to answer that.
I apologize. I think that I deleted it.
Okay, well, let's go on.
If you give 3 days up front, is that in lieu of the full 8 days?
Yes. And there's no carryover. So the employee gets the 3 days. They can use those 3 days. If they're sick on January 1st through January 3rd, they can take those 3 days off. They use their 3 days and they have no more pay. There's nothing to carry over.
Okay, it looks like we're at our last question here. What is the estimated cost for the Rose Group to write an employee handbook?
We don't, let's be clear that we don't write the employee handbook. What we do is we review the handbooks. The writing of the handbook is really kind of putting pieces together. You don't need a lawyer to do that. What you need the lawyer for is to review either your handbook and to give you some idea of what policies and procedures to put in it. I don't remember exactly what we had set up with the organization, but it's something like our review is something like $800, and that would include a sit down to discuss what changes need to be made.
Okay, I can reach out to the person who asked and email the preferred pricing agreement that we have with the Rose Group. We can touch on that again.
Or for anybody else who is interested, we will we'll certainly work on the same terms.
Yes. It looks like another question came through. Under the new sick leave law, once an employee surpasses the 3-day limit of sick days, is there I'm sorry, is other sick time just unpaid time off? Huh.
Well, if I understand the question right, yes. Assuming they don't have any like PTO or vacation that they could also use for sick time. If the employee is sick and are unable to work, they don't have to be paid.
Okay, great. There were a lot of questions that came through. Thank you so much for touching on all of those.
Okay, and I would say if anyone has other questions, you'll see on our slide we have our email address, and you can contact us, or you can get a hold of Veronica, and we'll be happy to answer the additional questions that you weren't able to ask in this session. Thank you very much, everybody. Have a great day.
Great. Thank you, everyone. Bye-bye.